I'm really flattered, I must say, and I'm also touched by the documentary which some of you prepared. Really, it was sort of a journey for me in the past, in my career as a judge of 17 long years. Ladies and gentlemen, the subject of my talk is Judicial Activism for Social Justice, Promises and Perils. Let me begin with some prefatory observations. In his book, The Rule of Law, Lord Bingham quotes the words of Thomas Fuller: "Be you never so high, the law is above you." The rule of law is the bedrock of all modern constitutional democracies, and it is the closest we have to a universal secular religion. The question is, however, who makes the law? Parliament or the judiciary? The traditional orthodoxy was that the Parliament makes the laws and the judiciary interprets them. The advent of judicial activism had challenged this judicial orthodoxy. Broadly speaking, judicial activism may be defined as the imposition of a judicial solution over an issue that was earlier subject of political resolution. There are many who argue that judicial activism really amounts to usurpation of power by an unelected court and violates the doctrine of separation of powers. It is nothing but transgression by the court into the domain of legislature and executive. On the other hand, the admirers consider judicial activism not as an aberration, but as a normal judicial function. Be that as it may, activism has brought extraordinary power to the Indian judiciary. The Indian Supreme Court has emerged in recent times as the voice of constitutional governance in the face of a weak executive. While analyzing this phenomena of judicial activism, we must note at the outset that judicial activism is inherent in the judicial review. So while making interpretations, the court can follow two models of judicial review. One is a technocratic model in which judges merely act as technocrats and hold a law invalid only if it is ultra vires the power of the legislature. In the second model, a court interprets the provisions of the Constitution liberally and in the light of spirit underlying it, and keeps the Constitution abreast of the times through dynamic interpretation. A court giving new meaning to a provision so as to suit the changing social or economic conditions or expanding the horizons of the individual rights is said to be an activist court. Let me give you the example of two recent judgments of the Supreme Court on death penalty. In the first case, that is Bullock's case, the issue before the court was, it was a two-judge. The issue was whether inordinate delay in deciding the mercy petitions would violate the right of the prisoner, his right under Article 21 of right and liberty and life. The two judges said that it is not fatal, delay is not fatal, since the convict the prisoner was convicted for terror offences. So this was a very restricted interpretation of Article 21. And now this judgment has been overruled by a 3-judge bench holding that delay would be fatal whether a person is charged for terror cases or non-terror cases. And this 3-judge bench led by the Chief Justice of India, Justice Shah, has shown great sensitivity towards the plight of a prisoner who is on the death row for a number of years. Justice Professor Satyaranjan Sathe, a renowned scholar, he has a very interesting theory about judicial activism. He says that the activism can be positive and negative. It can be progressive or reactionary. A judicial interpretation, according to him, that furthers the rights of the disadvantaged sections or imposes curbs on absolute power of the state or facilitates access to justice is positive activism. On the other hand, a court which maintains status quo in power relations is said to be a negatively activist. Now, he gives 2 examples of the decisions of the US Supreme Court, one in Dred Scott and the other in Lochner versus New York, as examples of reactionary judicial activism. In Dred Scott, the US Supreme Court upheld slavery as being protected by the right to property. The US Supreme Court said that ultimately slave is a chattel, and so this is slavery is permitted by the right to property under the American Constitution. In Lochner versus New York, the court held that a law made by the legislature against child labor, against employment of children in factories, is violating of due process clause in the Constitution. So these are the examples of negative judicial activism. On the other hand, Brown versus Board of Education, which is a very famous case, where the Supreme Court, US Supreme Court ruled that segregation on the ground of race was unconstitutional. Before that judgment, the American court adopted the principle of equal but not the same. As a result, there would be separate segregation between the black students and the white students, and also segregation in all walks of life. In my opinion, it's very difficult to say which judgment is a positively activist judgment or which can be said to be a negatively activist judgment, because judicial activism has to be dressed in the role of the court as counter-majoritarian institution. So judicial activism has really no permanent essence. You will find its history replete with different judicial responses at different times. Now, before we discuss the Indian experience with judicial activism, let us just take a brief survey of the understanding of judicial activism in the major common law jurisdiction. And I will briefly refer to only 2 countries. One is United Kingdom and the other is USA. In England, the very thought of judicial activism was blunted by the parliamentary supremacy. In England, the court merely interprets the law. The court cannot inherit the law passed by the parliament. There were some attempts by the court to secure such power of the court in past. For instance, in 1610, Lord Coke attempted to achieve this power for the court in Burham's case. It all failed miserably. So it was established for several centuries that Parliament is supreme and the court has no power to invalidate law passed by the Parliament. So the courts in England have therefore directed judicial activism against the executive and only subtly against the Parliament without challenging the Parliament's right to make the legislation. But in England, there is a pockets of change. The first change is that English law is slowly merging into the rest of Europe. Secondly, there is a subtle shift of power. The power of center was London. Now we shifted to Strasbourg. The judgment of the UK Supreme Court can be questioned in the European Court of Human Rights located at Strasbourg. And lastly, there is a Human Rights Act of 1998 passed in UK. Therefore, any law which violates the Human Rights Act has to be declared as invalid. In US, the courts have had the power of judicial review since Marbury versus Madison, which was decided in 1803. What you talk about today about judicial review, judicial activism, the story begins with Marbury versus Madison. In that case, the court held that it has power to strike down the Congress, any acts passed by the Congress, if they are contrary to the express provisions of the Constitution. Now, in US Constitution, there is no provision of judicial review, unlike our Article 226 or Article 32 in Indian Constitution. Chief Justice Marshall said that this power is implicit in the Indian Constitution. But unlike India, the American court's judicial activism has come under a lot of criticism. In 1930s, President Roosevelt passed a series of social legislations providing for maternity benefit, for minimum wage, for restricting the employment hours. All those legislations were struck down by the US Supreme Court on the ground that they violated the due process clause in the Constitution. So those judges were branded as reactionary by the liberals. And when in 60s the Warren Court sought to expand the rights of African Americans, the conservatives called the judiciary adventurist. After the decision in Brown versus Board of Education, the conservatives threatened to impeach the judges and burn effigies of Chief Justice Warren. I mean, you must have read about the recent example of the politician being critical, American politician being critical of the US Supreme Court judges. There was a joint session of the Parliament of the Congress, which was addressed by President Obama. The judges of the Supreme Court were also present in that meeting. President Obama was very critical of the judgment given by the US Supreme Court, whereby they struck down the limit on the funding of political parties by the corporate. President Obama criticized the judges in very strong words, and therefore the activism in US is always a very dicey thing. Jane versus Roe versus Wade was a very famous decision about the right of a woman for abortion, and still, even after almost after half a century, still the debate goes on in the US Supreme Court whether the court has crossed the boundaries of activism and has given a judgment which can be branded as adventurist. So, for India, I mean, it's a different story. Indian Supreme Court has transformed itself into an institution to promote the ideals of socio-economic and political justice. For some people, Indian judiciary is a sanctuary of Indian humanity, and for others, it is the most powerful court in the world. The transition came about slowly but drastically and offers a fascinating study. Friends, my speech would be broadly in 4 parts. The first part deals with the approach of the Supreme Court during the period 1950 to 1975. During this period, principally, the constitutional discourse was about the issues pertaining to land reform legislations, which were subjected to several constitutional amendments. Then the second part will discuss the transformation of the Supreme Court post-emergency period. The court transformed itself from a positivist court to an activist court, and this period is also marked by steady expansion of fundamental rights by reading into them non-justiciable socio-economic rights. The third part shall deal with the novel procedures of social action litigation, which is commonly known as the public interest litigation, about which Dr. Shah spoke extensively. So we'll talk about the access and democratization of the judicial process. And finally, we'll discuss the role of the court in the modern democracy and the issues of legitimacy and efficacy of the PI. Let's begin with the first part, that is judicial activism from the 1950 to 1975. From the very inception, the Supreme Court of India strictly followed the tradition of the UK courts, British courts, and thereby began as a positivist court. In a decision rendered immediately after the birth of the Constitution in A.K. Gopalan's case, which was a case of a detained under the preventive detention law, the court took a very narrow view of Article 21, and the court remarked, and those words are very important, outside the restricted field of constitutional limitations, our parliament and the state legislatures are supreme in the respective legislative fields, and in that wider field, there is no scope for the courts in India to play the role of the Supreme Court of the United States. This perception changed by 1967 when the court delivered the judgment in Gorakhnath. The court said that the parliament could not amend the constitution to take away or abridge any fundamental right in part 3. 6 years later came the Keshavananda Bharati's case, for which also Dr. Shah spoke. The court evolved another far-reaching doctrine under which Parliament was denied the power to amend in a manner that violated its basic structure. The court also identified the power of judicial review as a basic structure of the Constitution. This power made the Indian Supreme Court the most powerful court in the world. It also made it supremely political because the ultimate determination of basic structure was bound to be a political judgment. In 1975, an emergency was imposed by, this is following Prime Minister Indira Gandhi's disqualification in her election case. The emergency witnessed a large-scale violation of basic rights of life and liberty. Many politicians, journalists, and social activists were arrested under the Maintenance of Security Act. These detentions were challenged before the court of law. They met with the government's plea that Article 21, which guaranteed the rights of life and liberty, is the sole repository of that power, and as that right to move that court for enforcement of that right is suspected by a presidential notification, then all petitions are dismissed at the threshold. This objection has been overruled by 9 high courts who showed great courage in upholding the fundamental freedoms of detainees who were arrested arbitrarily or illegally. This was, however, reversed by the Supreme Court in ADF Jabalpur versus Shikhan Shukla, which granted a carte blanche to the executive to detain any person with no relief whatsoever from the court. During the hearing, the then Chief Justice of India, Siddharth Shankar Ray, asked the Attorney General what would happen if a person is shot dead. The director replied that no, even in that case, the court has no power to interfere. So this decision in Jabalpur was criticized by everyone. I mean, Professor C.K. Allen, a great constitutional expert, said that this judgment is the Supreme Court's contribution to the emergency. And then the turning point came from the Indian Supreme Court. The court realized that even if it had a power to invalidate a constitutional amendment, it can override the majority of the parliament. Still, its weakness, its judicial weakness, revealed in that area of Jabalpur case. The decision cost the court the social esteem it enjoyed. For the common people, the court was an elitist institution which supported the political establishment. So post-emergency activism was probably inspired by the court's realization that this elitist social image would not make it strong enough to withstand the future onslaught of a powerful executive. Therefore, consciously or unconsciously, the courts began moving in the direction of people. In this connection, I would like to discuss only one case, and that is Maneka Gandhi's case, which was delivered in 1978 by Justice Bhagwati. When draft constitution was being discussed, Article 21 contained a due process clause. Article 21 read, no person shall be deprived of his life and liberty except due procedure of law. Now, an American judge, Professor Justice Felix Frankfurter, he advised the Secretary of the Constituent Assembly, Mr. Rao, to delete this clause. So finally, as we read now, Article 21 says that it shall be not except by way of procedure established by law. This by way of procedure established by law are the words we borrowed from Japanese constitution. So what happened is, it was Article 21 was very narrowly interpreted in A.K. Gopalan, and in area Jabalpur it was completely annihilated. So then the effect was that the right to life and liberty depended upon the sweet will of the parliamentary majority. Then came the Maneka Gandhi's case. It was relatively a small case. The issue was whether the passport was impounded rightly, whether the provisions of the Passport Act were followed. And this case could have been decided without wider constitutional implications. But the court, while deciding this Maneka Gandhi's case, breathed life into Article 21 and introduced the concept of due process by judicial interpretation. So after Maneka Gandhi, a law depriving the person of life and liberty only had to be fair and reasonable, but also had to meet the possible challenges under Article 14 and Article 19. In the earlier judgment in A.K. Gopalan, the court said that each article is to be separately applied. When there is a challenge under Article 21, you cannot resort to the other articles like Article 14 or 19. With such expansive interpretation, the court recognized the rights of the under-trial prisoners, children under juvenile delinquency, re-examined the validity of the provisions of the penal law, where the court introduced the rarest of the rare principle. The court recognized the right to privacy, the right to a speedier trial, the right to independent judiciary, the right to efficient and honest governance. So the concept of even the personal liberty was expanded by giving a broad and expansive interpretation to including various human rights, including the right of women not to be subjected to sexual harassment at the workplace. That was judgment in Vishakha's case, which we will discuss slightly later. The court also started looking to the other parts of the Constitution, and this is really the main subject of my speech. They started looking into the other chapters, and that is, and one of the chapters is about the directive principles. Now, framers of the Indian Constitution followed the model of Irish Constitution, which differentiates in its Bill of Rights between justiciable rights and non-justiciable directive principles. Part 3 of the Constitution contains civil and political rights, and Part 4 contains the social economic rights, which are called the directive principles of the state policy, which although aim to be fundamental in the governance of the country, they are made expressly non-justiciable. Article 37 states that it shall be the duty of the state to implement those, apply those principles, but they shall not be enforceable in a court of law. Now, the traditional view is that there is a distinction between civil political rights on one hand and the socio-economic rights on the other hand. Civil political rights can be enforced by the court because they give rise to justiciable duties of restraint. On the other hand, socio-economic rights are associated with non-justiciable political duties, positive duties. Now, you will find in the constitutions of, say, US or Bill of Rights of Canada or UK or even ECHR, there is no socio-economic rights are included in the Bill of Rights. I will tell you about an important judgment given by the US Supreme Court, and then you can see the difference between the approach of the Indian Supreme Court and the US Supreme Court. That case was called Dashni's case. In that case, a child approached, claimed that the state has not taken appropriate steps from preventing his father from abuse of his father, and therefore he invoked 14th Amendment. Now, 14th Amendment is similar to our Article 21, which says that no state shall deprive a person of his life, liberty, or property without due process of law. The US Supreme Court said no. The 14th Amendment does not give rise to any positive social obligation. The Indian Supreme Court, on the other hand, has recognized a range of positive duties on the basis of right to life. Rather than viewing the directive principles of state policy as simply unenforceable, it has drawn these principles as a rich source of interpretation of the justiciable civil and political rights. The court has negated the view that these fundamental rights and directive principles are mutually exclusive. The court enlarged the concept of life in Article 21 to include the dignity of the individual and worth of the human person. The court said that the life does not mean mere animal existence or continued treasuring. The life is, there are finer graces of human civilization which makes the life worth living. Thus, the right to life has been held to include the right to primary education, the right to work, right to livelihood, right to shelter, and right to childhood. So what the court started doing is, every socio-economic right is read in the Constitution as a part of the right to life. Now, whether this approach is correct or this is an oversimplification of the constitutional rights, we will discuss it slightly later. But one thing I must tell you, that these judgments of the Indian Supreme Court proved to be great inspiration for the other countries, and some countries have completely abolished the distinction between the justiciable civil political rights and the non-justiciable socio-economic rights. For example, South Africa, Finland, Kenya now provide, there are new constitutions. They provide for justiciable socio-economic rights. And out of this, I want to place before you the experience of the Constitutional Court in South Africa. That according to me, every student of law who is interested in the enforcement of the human rights by the court should read some of the judgments delivered by the Constitutional Court of South Africa. In South African Constitution, Section 7 says that the state must respect, protect, and promote and fulfill its rights in a Bill of Rights. However, instead of immediate duty to enforce their rights, the duty is progressive one and it is subject to reasonable measure within the available resources of the state. Section 26 of the South African Constitution provides that everyone has a right to have access to adequate housing. Section 27 says that every person has a right to have access to healthcare services, then sufficient food and water, and social scrutiny, and so on and so forth. Now, what the South African court said that there are three principles which are important about the enforcement of socio-economic rights. First is the principle of accountability. Accountability of the government towards its people. Second is the principle of deliberative democracy. Court cannot just impose its will on the government because the government is formed by a representative of the people. So deliberative process is very important in deciding these issues. And thirdly, the addressing the inequality. If there is a clear hint of inequality, then the court may interfere. I would like to discuss only three cases very shortly before you. The first case was called Subramanian. Now in that case, the applicant suffered from heart disease and renal failure. He claimed that his right to life and emergency health treatment had been breached when he was refused renal dialysis, which would have prolonged his life. The hospital argued that it had a very small number of patients who did not suffer from heart disease. And those who suffer from heart disease are really cases for kidney transplant, not for permanent dialysis. Because there is no use in giving this treatment because heart patient cannot survive for a long time. The court sought to harmonize the conflicting pulls of shortages of resources and the high levels of demand. It stated in its decision that these choices involve difficult decisions to be taken at the political level in fixing the health budget and the fundamental level in deciding about the priorities to be made. And this should be ordinarily left to the government and the health authorities. So in the first major case, the applicant's claim for violation of right to life was rejected. The second case came, that is group rooms case, and that was a major case, and it has been followed by, actually I had an occasion to follow this case in Delhi High Court when we decided upon the right of housing. Here the court talked about the reasonableness and not only the accountability and also the value of equality. In that case, a family was living in a squatter colony near Cape Town for a long time. There were terrible conditions in that squatter colony. So they were on the wait list of the allotment of a low housing by the government for 7 years. So finally they shifted to a private land. They were evicted from the private land. Then they squatted upon a municipal sports ground. And this is how the matter went to the court. The court said that, recognized that there is an overwhelming housing backlog. Why it happened for black people? Because during apartheid period, blacks were not allowed to stay in urban areas. They were all required to live outside the main cities. So the court said that national program of housing does not provide relief for those in desperate need. These families are really in desperate need. The court did not impose on the government that they should provide housing for those particular black family, But the court said that you must make a provision for reasonable provision for providing housing to those in desperate need. This was the second case where they established that in case of inequality, the court can interfere. The third case is the NLC case known as, this is Minister of Health versus Treatment Action Campaign. I don't know, some of you might be aware of this medicine called nevirapine. This medicine diminishes the chances of transmission of HIV virus from the mother to the child. So, in South Africa, the government was headed by a gentleman by name Hon'ble. Now, this Hon'ble government said that no, there's all this scientific evidence that AIDS is caused by HIV virus is not acceptable. So, the government maintained that AIDS is caused by poverty and malnutrition. So, they did not allow this nevirapine to be used in government hospital. Nevirapine manufacturers said that they are prepared to supply this free of cost for 3 to 5 years, but still the government maintained that it will not supply this in the government hospitals. And there the court invoked the principles of inequality and said that the government cannot treat these women, the pregnant women, unequally and allowed forced the government to supply this particular drug in the hospitals. Now, in contrast, you take the decisions of the Indian Supreme Court. With no disrespect made to the great judges who really construed Article 21 in a very expansive way. But see, we talk about the right to shelter. It has been laid down that right to shelter is covered by Article 21 in the right to right. What the court has done about thousands of forced eviction all over the country. Every year thousands of slum bearers are evicted. The court has not said anything. We'll come to the Olga Tilly's case and the subsequent judgments. Really, what is the use of just saying that the right to shelter is implicit in Article 21? It's only a lip service. It's not really it's a symbolic gesture and not really any constructive provision for the common man of this country. Right to livelihood, right to work. They say it's a part of Article 21. It is read in right to life. See the judgments of Supreme Court, Indian Supreme Court in last several years. And you will find, particularly the judgment of, I'm sorry to mention the names, Justice S.B. Sinha, Justice Pasai, number of judgments. All those judgments really negate the right to work. It has completely diluted the labor jurisprudence which was developed by the great judges in 60s and 70s. So I feel that merely expanding the right to life is not a sufficient step to really give justice to the common man of this country. With this, we come to the third part, where the growth of PIL. Let me start at the beginning. In 1979 and 1980, 33 detainees were blinded by prison authorities in Bhagalpur, in the state of Bihar. I don't know, some of you might have seen that movie called Ganga. Yes. So they were blinded in order to coerce their confessions. A newspaper journalist wrote a scathing expose and a lawyer sent this article to the Supreme Court. This resulted in the birth of what was known as epistolary jurisprudence. The court ordered the state of Bihar to provide medical treatment for the detainees and pensions for their families, and in subsequent hearings monitored the rehabilitation of those victims. See, for a long time, the Indian court procedure was drawn from Anglo-Saxon system, leaving most of the citizens unaware of their legal rights, much less in a position to assert them. Most of the citizens don't know their rights. And the guarantees of fundamental rights and assurances of directive principles, which are described as conscience of the Constitution, are really only empty promises for the majority of the illiterate and indigent citizens of this country. Now these instances the court started taking up these causes in public interest, brought about a major transformation and standing, and finally in 1982 the court said that any person can bring a cause on behalf of a disadvantaged section. What happened to public interest litigation in 90s and thereafter in 2000 is a matter of other discussion. So this transformation of these public interest litigation and the law about standing, it began gradually with the determination of the first letter written by Mr. Sunil Batra to the Supreme Court. He complained against the torture of a fellow prisoner, and this is how the Supreme Court laid down the jurisprudence on prisoners' rights. Then came the habeas corpus case, where Kapila Viborani, a lawyer practicing in the Supreme Court, pointed out that 18 detainees were still languishing in the jail, still facing their trial, beyond the period which they would have, even if they had been convicted, they would not have remained in jail. Beyond that time, they were still languishing in jail. The Supreme Court appointed a commissioner and taken up this case. 80,000 such prisoners were found in the prison who were detained in jail beyond the maximum period of their sentence. And they were eventually, the Supreme Court monitored this case and eventually they were released. And therefore, this is how the Supreme Court began really the process of fulfilling the constitutional promises and started acting what is known as social auditor. So the Justice Bhagwati's words I would like to quote before you. He said in Dr. Upendra Bakshi versus State of UP, what is a PIL? What was the original idea of a PIL? Was it to take action against the hearing officer? Was it to give only reparation to the victims or to the petitioners before the court? The court said it must be remembered that this is not a litigation of an adversary character undertaken for the purpose of holding the state government or its officer responsible for making reparation, but it is a public interest litigation which involves a collaborative and cooperative effort on the part of the state government and its officers and lawyers appearing in this case at the bench. So it's a collaborative process amongst all of them, and they very deliberative process, they come to the conclusion, they decide about the course of action. Now we come to the Vishakha case, which according to me, which is the most startling order passed by the court, but it's a stunning order by any standard. What happened in that case, the Supreme Court said, notice that there is no law in the country which protects the women against sexual harassment, even though India has ratified international conventions. The court said that the government of India had made these legal commitments concerning women's equality by ratifying CEDAW, and the court should ensure that India's promises are realized. And the courts framed the guidelines and declared those guidelines as the law of the country. And it said that until the parliament makes the law on this subject, this will be followed by all. So this was not a judicial legislation in the reality jurisprudence, but it was a case of a court passing a regular legislation. Same thing was done in Lakshmikant Pandey, where the court framed guidelines about the interstate adoption by the foreigners. I would like to go to the two cases and come to the last part of my lecture. That's about the criticism of the present day PIL. The two cases I am citing because I was party to one of the cases, and that is the cycle rickshaw case. This Punjab Cycle Rickshaw Act provided that licenses to ply a cycle rickshaw can be issued only to the owner of the rickshaw. So if the owner has rented cycle rickshaw to somebody, then that person will not get a license. This act was challenged naturally on the ground that it would affect the right to carry on any trade, business or occupation guaranteed under Article 19(1)(g) of the Constitution. The Supreme Court in 1987, speaking through Justice Kushnagar, instead of striking down the law, said that Punjab government should give loans to those persons who are plying the cycle rickshaws through the nationalized bank, and they will buy their own cycle rickshaws, and then therefore the court refused to strike down this law. But nothing happened. No loan was given, and anyway the law continued. The Supreme Court judgment was that such a law would be valid. 20 years after the judgment of the Supreme Court, the owner-plier policy again came into challenge before Delhi High Court. Now Delhi government has limited the number of cycle rickshaws to only 99,000. In fact, there are 1 million cycle rickshaws being plied in the city. The limit on this 99,000 was challenged, and they said that this policy is unconstitutional. So we heard that though the Supreme Court has upheld this similar law, after 20 years of gap, it has now become unconstitutional, and it is the first instance where the High Court must have said that the law laid down by the Supreme Court need not be followed, and this particular provision was declared erroneous. And fortunately, this judgment was upheld by the Supreme Court. Then the only other case I would like to note is the right to food. So the right to food case, why I am mentioning before you, is right to food is treated by the Supreme Court not as a socio-economic right, but as a civil political right. And therefore the Supreme Court said that there should be an immediate compliance with this their direction to right to food. And then the Supreme Court has given direction about the midday meal scheme, etc. Now it is true that there is a lot of allegations of corruption, a lot of inadequacies in the midday meal scheme, but this was a great step taken by the Supreme Court to say that all such, the right to food has to be implemented at any cost. PIL was started, in 78 or early 80s, it started with money barriering. But there are some serious concerns about the PIL in India. And there are some important lessons in the PIL, the orders passed by the court, for all of us, for the judges, for the lawyers, and for the academicians and students. I want to raise before you 3 issues. First is the issue of legitimacy. Second issue is the issue of efficacy of the PIL. And the third is, I'm really concerned, is the creeping elitism in the court. Now there is a lot of criticism of the Supreme Court. Many people feel that the court has clearly translated the limits of judicial functions and has undertaken functions that really belong to either the legislature or to the executive. The court has not only changed with exceeding its institutional capacity, but with reversing constitutional priorities, usurping both legislative and judicial and executive functions, and riding roughshod over traditional rights. I can give you some examples. There was an order passed by the Indian Supreme Court directing the government of India to start the project of linking of rivers in India. Almost all experts in the field, they said that such a project is not feasible. Cannot be enforced. Nonetheless, the Supreme Court, he said at the threat of contempt, the central government was asked to start this process of linking of the rivers in India. Now there are some other matters which are very strangely are taken by the court. For instance, there are matters like wild monkey menace in Delhi. how the courts are concerned with the monkey menace, I mean, how the court would tackle these issues. Then ordering exclusion of tourists from the wildlife area. I really don't know how this falls within the function of the court. Then there are some other management exercises like the removing that dark glasses of the motor cars, etc. These are really not the matters which ought to be dealt with in public interest litigation as originally envisaged by the Indian judiciary in 1970s or 80s. The other orders which you may consider, one was fortunately reviewed, that is, you can appoint the Information Commission only judges as Information Commissioner. I don't know where from you get this power to foist the judges in Information Commission. Then there was you have all read about the orders passed by the Indian Supreme Court to protect the environment. I mean, some of the orders are really, laudable, there is no doubt about it. But take the case of the Supreme Court order in that Godawaran case. In Godawaran, the Supreme Court issued a sweeping order stopping all sawmills and felling of trees in the forest area. Now, as a result, those tribal people, they are the original inhabitants of this country. Those who were residing in the vicinity of the forest, they were all seriously affected. They are the original residents, inhabitants of this country, and they are regarded as encroachers by the order of the Supreme Court. So this is a serious concern about I would say, this is the politics of judicial activism, where the court is rather, ruling, acting as a pejorative court than the counter-majoritative court. The second is about the efficacy. I would just quote the observation of a foreign observer about the PIL in India. He said, one of the most striking aspects of the Indian legal system is the extent to which formal legal arrangements exist in almost metaphysical isolation from social reality. It is hardly surprising, therefore, that while public interest litigation may have secured some relief to few individuals, it has not ended bonded labor, not found homes for Bombay pavement dwellers. Litigative strategies can never substantially redistribute wealth or power, nor penetrate and affect the economic and cultural conditions which define the reality of Indian life. As a former Chief Justice has said, we must always remember that social action litigation is necessary and valuable ally in the cause of the poor, but it cannot be a substitute for organization of the poor, development of community self-reliance, and establishment of effective organization structures which the poor can combat exploitation and injustices. Lastly, I will speak about the creeping elitism. In 70s, a reporter in Bombay by name Ulga Tillis filed a petition in the Supreme Court to prevent disposition of the forceful eviction of the squatters of the footpaths of Mumbai. Mr. Hon'ble was the Chief Minister at that time, and he issued a farman that all these people should be removed from there. They should be given some 1,000 rupees each and should be sent wherever they came from. So this matter went to the Supreme Court, and the court reasoned that the eviction of the public lands of these squatters mean a loss of livelihood to them. The court said that it is really Article 21 issue. And Justice Chandrachud said, and his observations are worth quoting, it is these men and women who have come to the court to ask for a judgment that they cannot be evicted from their squatted shelters without being afforded alternative accommodation. The court was very sensitive to the problems of the hut dwellers. Of course, the court could not solve the problems, but it was definitely sensitive. In 1996, from 1996, we have this spurt of public interest litigation filed by the environmentalists and middle class property owners. They started filing petitions in the High Courts and the Supreme Court, asking for the removal of these slums. In a waste disposal case called Abitra, initiated by a public interest litigant committed to the improvement of urban environment, the court characterized, mark the words, the court said that this giving alternative accommodation to a hutment dweller is as rewarding a wrongdoer. According to the court, the promise of free land at the taxpayer's cost in the place of a chukki is a proposal which attracts more land grabbers. Rewarding an encroacher on public land with free alternate site is like rewarding a pickpocket. So the hutment dwellers whose dignity was considered to be the citizens of India and whose dignity was right to dignity was considered by the Supreme Court, they became like pickpockets. In another PI litigation, which was filed in Bombay High Court, there was an informal colony in Sanjay Gandhi National Park where I think 500,000 people resided in that colony. The whole of the colony was removed on the orders of the Bombay High Court. Justice Krishna described them as judicial field marshals. Arranging the troops and removing the squatters from the place. A similar decision was given by Delhi High Court on both the unauthorized colonies on Yamuna Bank. Again, lakhs of people were removed from that particular Yamuna Bank, and most strangely, this Hon'ble village came in the same place where the unauthorized colony were removed on the ground that they are danger to the environment. So, ladies and gentlemen, I discussed the concern of legitimacy, efficacy, and criminal elitism that threaten to tarnish India's excellent record of socially progressive judicial activism. It is also my belief that the process of rights expansionism cannot be taken too far. Recent decisions of the Indian courts have perhaps crossed that line. Everything is to be put under Article 21. In a case of earlier, I think it was 2 years back, a police action was taken. I think Professor Baba Ramdev, he raised some shibir, and there was on Ramlila Maidan, and there was a police, removed them at midnight. The court said that this is violation of the right to sleep peacefully. Now this could be a constitutional right, and surely, while describing this as a right, the court said that certain persons are excluded from this right, and one of the categories is homeless people. So homeless people have no right to this so-called right to sleep peacefully. So this is how we are expanding Article 21, and willy-nilly we are really making mockery of this expansionism of Article 21. In recent time, we also see a class of consumers who have developed vested interest in use of PI. A particular urban class is now on the forefront of invoking the rights of the court under Article 226. The result has been that the judicial activism is at once a peril and promise. Professor Bakshi says, and I would conclude with his words, the growth in constitutional faith overloads adjudicated power with great expectations, which it does not quite efficiently manage and which it may not always fulfill. The result has been that judicial activism is at once a peril and a promise, an assurance of sovereignty for the depressed classes as well as a sign of betrayal. Indeed, courts are, at the end of the day, never an instrument of good social revolution. They are best instruments of piecemeal social engineering, never a substitute for direct political action. So, thank you very much for listening to the question.
Thank you, Lordship, for such an enlightening lecture on judicial activism. I quote from Bible. It is said that a person who has got the thirst and hunger for justice is God's man. And here we have such a person.